The Constitution of the United States, Amendments 21 through 27. Amendment 21, passed by Congress February 20th, 1933, ratified December 5th, 1933. Section 1. The 18th Article of Amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Amendment 22, passed by Congress March 21, 1947, ratified February 27, 1951. Section 1. No person shall be elected to the office of the President more than twice, and no person who has held the office of President or acted as President for more than 2 years of a term to which some other person was elected President shall be elected to the office of President more than once. But this article shall not apply to any person holding the office of President when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of President or acting as President during the term within which this article becomes operative from holding the office of President or acting as President during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress. Amendment 23, passed by Congress June 16, 1960, ratified March 29, 1961. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as Congress may direct a number of electors of President and Vice President equal to the whole number of senators and representatives in Congress, to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of President and Vice President to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th Article of Amendment. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 24, passed by Congress August 27, 1962, ratified January 23, 1964. Section 1. The right of citizens of the United States to vote in any primary or other election for President or Vice President, for electors for President or Vice President, or for Senator or Representative in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other tax. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 25, passed by Congress July 6, 1965, ratified February 10, 1967. Note, Article 2, Section 1 of the Constitution was modified by the 25th Amendment. Section 1. In case of the removal of the President from office or of his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President acting as President. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the Executive Department or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose if not in session. If the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session, within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. Amendment 26. Passed by Congress March 23, 1971. Ratified July 1, 1971. Note, Amendment 14, Section 2 of the Constitution was modified by Section 1 of the 26th Amendment. Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 27. Originally proposed September 25, 1789. Ratified May 7, 1992. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened.